I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back, everyone, to the Legal Briefs. I'm your host, Alice, and I'm privileged to get to introduce you to my stunning co-host, Brett.
Oh, I see what you did there, Alice. Everybody knows how much you love puns, and you have masterfully pulled one off today.
Well, you see, I was thinking about introducing you as my privileged co-host, but that's not really positive. And so I was trying to work in privilege because guess what, Brett? We're talking about privilege today.
We sure are. And this is another one of those, as we like to say, you guys are going to get tired of us talking about this all the time. This is one of those that you guys suggested that you were interested in hearing about. We've sort of danced around it a little bit in the last couple episodes, and it really led some people to ask some questions about, why do we have these privileges? What's the point? You know, why is it that in the case of Lizzie Borden, it's 120 years later, and the law firm is still, to this day, claiming that they have a privilege? How does that work? And what about other privileges beyond just the attorney-client privilege? So we wanted to talk about some of that stuff with you guys because it really actually is a fascinating part of the law.
Absolutely, Brett, especially because there are actually very limited number of privileges and also very limited circumstances in which they apply. But we hear lots of other types of privileges thrown around in the media or in movies and other podcasts maybe, but you should be informed whether those privileges actually exist and whether they can be invoked. So first of all, let's break it down.
And, you know, this goes without saying, but I just want to say we are talking about privileges in the United States. Privilege is one of those things where it really depends on where you are. So if you're in Britain or somewhere else, the privilege law is probably entirely different because this is one of those things that is all over the place.
Absolutely. And so because we are talking about privilege in the United States, let's break it down really quick and just define what we mean when we talk about privilege. So generally, when you are subpoenaed or court ordered to testify in court, you have to show up. You can't just say, nah, I don't really feel like showing up. You have to show up, and typically you have to answer questions posed to you, unless a privilege applies. That's an exception to the court's power to compel you to testify. And so that's kind of the broad meaning of privilege when we talk about that. And the most common you've probably heard of is attorney-client privilege. And that is a privilege that exists, as it sounds, between the attorney and someone that has hired them for their services for purposes of litigation.
And we talked last time about some of the exceptions to this with evidence and that kind of stuff. If you want to listen to that, we talked about that last time. I'm not going to really get into that today. Today we're talking about more of the actual privilege, which is things you tell your attorney. It should be pretty obvious why you have this privilege. Sort of go back to the Constitution. You have a right to an attorney. And that right wouldn't mean much if whatever you're told your attorney was subject to subpoena by the government. I mean, you would be better off not having an attorney because whatever you told them, he would have to testify to. And going back to hearsay, because we're going to talk about hearsay some, because hearsay comes up in this. Because you were the one who told it to your attorney, there's no hearsay exception. So you would be in some pretty bad trouble. So the thing about attorney-client privilege, which is interesting, it is the only sort of constitutionally required privilege. You can't really have your constitutional right to an attorney without that privilege. And so if you look at the federal rules of evidence, which are the basis for most of the rules of evidence in the states, it has a section on privilege. A whole section is carved out for privilege. And there's exactly one rule in it, and it is the attorney-client privilege. Because it's the constitutionally required one, it's the one everyone can agree on. All the other privileges that you've heard of, spousal privilege, privilege between a priest and a penitent, privileges between doctors and their patients, psychiatrists and their patients. All those things, they exist in some places, but they've never actually become a rule because not everyone can agree on them. The only one that is rock solid that you have everywhere and anywhere that you're going to be is the attorney attorney-client privilege. And Alice, who holds the privilege?
So the client holds the privilege. And what that means is the client gets to communicate with the lawyer, but it has to be about legal advice, and the lawyer has to be acting in their professional capacity. And you understand why the client is the one who holds it, because you want the client, who's the holder of the knowledge, who is best able to assist in their own defense, to be able to divulge everything that is necessary for their attorney to know about their case, about themselves, in order to represent them as well as possible. So the client can actually go out and say, I told my attorney this. And that's actually happened before. Once the client does that, it breaks that attorney-client privilege because it wasn't said in private and it wasn't intended to stay private. And that's why oftentimes you'll hear, a third person has to leave the room if the client wants to say something to the attorney and intends it to stay protected by the attorney-client privilege. And that's because any third person who's not part of your representation team would actually break that attorney-client privilege. So that's why we say the client holds the privilege. It is not up to the attorney to use their own judgment and decide when they can divulge the information or be forced to give the information. And that's also why this privilege extends past the death of the client.
And it puts attorneys in a weird place, because there are times where the attorney really wishes he could assert the privilege and not have to show up and testify. For instance, no attorney wants to testify. But if the client waives the privilege, then all of a sudden you got to testify. And there's nothing you can do to stop it. You see this a lot in ineffective assistance of counsel, which is probably the instance in which the privilege gets waived the most. If you file an ineffective assistance of counsel claim, you are waiving your privilege. So you can't say your attorney is ineffective, but then prevent them from talking about anything you discussed. You can't do that. By saying they're ineffective, you're waiving that privilege. All of a sudden, that attorney has to testify about the advice they gave you and everything else. It also puts you in a weird place sometimes as lawyers. Alice and I had a trial, and the defense was asking someone about conversations which were clearly privileged. And this person, although they were part of the conversation, they didn't hold the privilege. So he's asking this person the question. I'm objecting, saying it's privileged, but the judge is like, well, do you have the privilege? And the answer, of course, is no, I don't, but the person who has it isn't here. And so it's this really weird situation where you have a lawyer asking about privileged information, but there's no one to actually assert the privilege. And that can be kind of a sticky situation. But generally speaking, this is as ironclad as you get. And the fact of the matter is, those people who have the privilege or holding on to those privileged documents in the Lizzie Borden case are 100% right. The privilege survives death. The only instance in which it doesn't survive death is when it's necessary to break the privilege in order to effectuate someone's estate plan. So if you need to break the privilege for the purpose of divvying up their estate, then that's not actually privileged material. But everything else survives death. And it's a really sort of interesting question. Why is it that we can't reveal this stuff so much later on? The law firm itself is in a position where it is beholden to the bar. So the Bar Association has rules about this. And if you're breaking the privilege, that is serious. That's the kind of thing you lose your license over. And you might say, well, you're probably not going to lose your license over breaking the Lizzie Borden privilege. But hey, lawyers take this stuff really seriously. So what you would need is basically someone that has standing to sue in a court to order these people to turn this over. If they were to do that, then maybe we could finally get to that historical information everybody wants to see. But generally speaking, death doesn't matter. That privilege lives on. Now, as we said when we were talking about the evidentiary thing, there are exceptions. And one of them is something called the crime fraud exception. You can't become a part of a crime if you're the lawyer. You're not allowed to do that. And if you're giving advice and representing someone in a criminal enterprise, I mean, say you're the consigliere to the mob. Just because you're the mob's lawyer doesn't mean that the prosecution can't get to you and make you talk because of this crime fraud exception. And it's a narrow exception, and it's a difficult exception to invoke, but it happens more than you might think, because a lot of times lawyers get pulled into the criminal activity of their clients, and that's obviously a bad thing for everybody, but it's also the kind of thing that breaks the privilege.
Absolutely, Brett. You're so good at this because you literally read my mind. I was about to talk about crime fraud. And the thing with crime fraud is, of course, there's the attorney who could be part of the criminal enterprise from the beginning. They know this is happening. But more often than not, partway through their representation, an attorney may realize that they are actually being asked to provide legal advice that would help their client commit a fraud or crime. And when they realize it, they actually have a duty of candor to disclose this to the proper authorities. But because that attorney-client privilege we talked about is so strong and so important and such a big deal, if you break it, attorneys don't act alone in deciding whether crime fraud exception applies to the communications that they're about to divulge. Rather, oftentimes you'll find that they actually try to go to an adjudicating body, whether it's a court or a bar, their local bar, to say, here are the reasons why I believe these communications fall under the crime fraud exception. Will you give me a provisional or an opinion that you agree with me so that I can turn these over and kind of immunize me from any claims that I have pierced the attorney-client privilege inappropriately. And so even in those situations, there's kind of a request for an outside or third-party adjudicator to cover themselves. And that's a tough situation to be in if you're an attorney, if you kind of realize partway through your representation that this is happening. But there are steps you should take in order to make sure you're covered in the event that maybe you were wrong, and in fact it was attorney-client privilege. But at least you've gotten the kind of the immunity from a third party who has looked at the facts as you've presented them and agree with you that it's more likely than not that the exception applies.
And this is the kind of thing that lawyers are really squeamish about. It is really bad if you're getting information that you're not supposed to get. And it's something that people try really hard to prevent. And this can be a difficult question. What does it mean to be assisting in the criminal enterprise? I told a story last week about a lawyer who helped someone who was selling drugs pay their taxes. So is that helping them in their enterprise? The answer is no, because you're helping them do something they're required to do by law. But if you help negotiate the contract between them and the cartel, that would be different. The other thing that you have is subpoenas can be really dangerous. You're issuing a subpoena to someone and you want all their documents, all their emails, everything else. Well, what if you get a bunch of emails between them and their lawyer? What do you do then? And so a lot of times in investigations, you'll have something called a taint team, which is a terrible name, but we're stuck with it, or a screening team or something. And it's just lawyers who aren't actually involved in the investigation. So they're not on the prosecution team. They're just other prosecutors, and they will look at everything that comes in, and they will decide what is attorney-client privilege and what is not. And if it's attorney-client privilege material, they put it aside. And your actual prosecutors, your actual people who are involved in the case, they never see that. They only see whatever's been screened and determined not to be attorney-client material. So there is a lot that goes in to protecting this privilege, probably a lot more than the average person knows about.
Absolutely. So that's attorney-client privilege. This was like a quick and dirty explanation of it. So another one I'm sure many of you heard about is the marital privilege. And this is actually not nearly as expansive as you may think it is. And it's misapplied oftentimes. People often say, well, it's for any special relationship, with my boyfriend or my girlfriend or my children, something like that. But no, this is actually very narrow. It is to someone that you are married to. It can be common law married, but if you don't have an official document, you have to jump through additional hoops to show that you are in fact common law married and not just invoking this privilege when it's convenient for you to prevent testimony. Basically what it is, in a nutshell, is that you cannot be compelled to testify against your spouse in a criminal trial, but lots of exceptions apply.
And this is one of those that's, archaic might be one way to put it. It is a weird little privilege because, as Alice said, we're talking about marriage here, and that's it. Your kids, you don't have a privilege. If I want to call you and force you to testify against your child, I can do that. Stupid thing to do. Probably going to lie, but I can do that if I want to. Your girlfriend, siblings, parents,
all of them.
All of them. All your other family members, there's no exception. It only applies to your spouse. And why is that? At some point a long time ago, and this is one that has a lot of longevity to it, but at some point people decided, it's really bad for a marriage if you're testifying against your husband or your wife in a crime, which is probably true. I can imagine that would lead to some tough times in the marital household if you are having to testify against somebody. And so they decided we're going to have this privilege. And it actually is divided into two. Alice has talked about the first one, which is you cannot be compelled to testify against your spouse. And a lot of movies and TV shows, Matlock and Perry Mason and all that stuff, they always get this wrong. It's she's my wife, she can't testify. Or it'll be one of those things where you're going to call them and then suddenly they get married, or a marriage certificate shows up and they were actually married a decade ago and they never got divorced. And so now you can't call your star witness to testify about what they saw. That is not how it goes. You can't be compelled. You can choose to. You can choose to say, thank you for trying to protect my marriage. I'm going to go ahead and testify against my husband or my wife anyway. You can decide to do that. Now, the only time that the marital privilege can be invoked, you do have to be currently married. So if you used to be married and you saw something and it was criminal and then you got divorced, you can no longer use that privilege, even if you want to. Now you can be compelled to testify. But there is another form of the privilege which survives divorce and which you cannot choose to waive. Either spouse can invoke it, and that is the marital communications privilege. So anything that you discuss with your husband or your wife while you're married is privileged. And even if you want to testify about it, you can't do that if your spouse won't allow you. So if you see him dragging a dead body into the house, you can choose to testify about that. If he tells you, well, honey, I just want you to know, because I love you and we're married, that I murdered somebody and I threw their body in the ocean. That is a communication, and you can't testify about that even if you want to. Doesn't mean you couldn't go to the police. Doesn't mean you couldn't tell them everything you know. But when it comes time for a trial in a court, you are not allowed to testify about that communication. Once again, there is the exception, the same exception that we have for the attorney-client privilege, which is crime fraud. If you're involved in it, if you're a couple who's committing crimes and you're discussing your crimes, that's not a get-out-of-jail-free card. It doesn't mean that neither one of you would have to testify against the other one, or if you chose to testify against the other one, that they could invoke the privilege if you're both involved in the crime. So it really has to be one person is a criminal or one person is innocent, and the criminal is telling their wife or husband things in this sort of marital bliss, and we don't want to invade that. Now, Alice, I feel like maybe this was a good idea when it got started, but other than being venerable and ancient, I'm not sure that this is one we should hold on to.
Yeah, I think that's right because of all the things we noted earlier. Family members in general, I think you can draw the same sorts of need to protect / desire to lie for them because, man, try to get a parent to testify against their kid. Impossible. We're talking sweet old lady, gray hair, bakes the casseroles at church. Doesn't matter. She gets on that stand. You try to get her to testify against her son and she will just lie her head off. And same with also siblings. Oftentimes people who are very close to their siblings who may be in a criminal enterprise together. They're not going to snitch on each other. They grew up together. They love each other. Their family, blood is thicker, that sort of thing. And so I understand what marital privilege is trying to get at, but in reality, in our line of work, we recognize a problem if our only or our best witnesses are someone who has a close relationship with the defendant, a family member, a spouse, even if we can somehow pierce it, or someone who wants to testify against their spouse. People change. They talk while they're incarcerated. They talk a lot. Their minds change when they realize how difficult it is with their loved one locked up. They change their minds. They may have children in common. And, the defendant may be using the children as some sort of leverage or even blackmail. And you just see that it's very difficult if your case hangs on a close relationship, especially a close family relationship. So in reality, I will say we generally try to make sure our case doesn't hinge on one of those close relationships, spouse or other family member, because we recognize that, humans are relational beings and we have loyalties that go far beyond what we think a court orders us to do.
I'll say this, I would be very nervous if my entire case rested on whether or not Mama was going to get on the stand and tell a jury what she told me. I would be...
Mama not going to do it. She is not going to do it.
She's probably not going to do it, and you better have more than that. And this goes to sort of, not really the topic of today's discussion, but something we've talked about before, prosecutorial discretion in deciding when to bring cases and when not to bring cases. This might be an instance in which you're absolutely certain the person's guilty. You got what you think is convincing evidence, but how much of it's actually going to make it for a jury? And if your convincing evidence is a very convincing statement by the mother that the son did it and she knows he did it because she saw the gun or whatever, that may be good enough for you, and it may be good enough for a grand jury, and it might be good enough for a jury if they heard it, but are they ever going to hear it? And you can impeach her all day long. You can put her on the stand and say, did he know about this? Did he do this? No, he didn't have anything to do with it. Well, didn't you say 3 months ago that he did it? I don't think most juries are going to care. Maybe they're going to say, well, she's just lying for him, as you would expect her to do. Maybe. But man, you are taking a chance. And as Alice said, when you talk about privilege, why is there a privilege? You really have to think about the reason, because privileges are kind of bad. I mean, we really don't like privileges. They're kind of a thing you only want to have if you absolutely need to have it. So you have the attorney-client privilege to actually protect your constitutional right. And without it, you wouldn't have a real right to an attorney. I think that's pretty clear. And here, the reasoning behind it is to protect your relationship with your wife, your husband. But it seems like it's equally strong to protect your relationship with your mother, your father, your children, your brother or sister. To me, being forced to testify against my child would be far worse than being forced to testify against my wife. And some people go the other way. I mean, some people say that's right, and so we should have more privileges. We should be privileged when it comes to parents and privileged when it comes to children. I will tell you that in the legal community, people who make the rules, judges, legislatures, they really don't like privilege for all the reasons we said. It, in a lot of ways, protects you from justice solely because of your relationship with other people. And that just doesn't feel right. That feels wrong. It feels like your relationship with someone else isn't the kind of thing that should prevent you from going to prison if you murdered someone, for instance. Everybody, we've talked about the Flores case where you have both a father and a son who are being tried for murder in the Kristen Smart murder. And everyone pretty much agrees that to the extent the father helped the son get away with it, that's a bad thing. That's usually how we feel. You wouldn't want to give him a privilege. You wouldn't want to say, well, he's in a privileged position relative to his son. So if his son told him something about murdering somebody, you can't ask him anything unless he's actually involved in the crime. So it's sort of a sticky situation, but we're not moving towards more privileges. We're actually moving towards fewer privileges. And so a lot of the privileges you hear about, particularly in the United States, think about doctor-patient privilege. In some other countries, there are laws that specifically protect information you share with your doctor. They're usually pretty narrow. They're not just anything you tell them, but if it's something actually related to your health, then it is protected. So you can't go to your doctor and be like, yeah, I got a pain in my knee. Oh, and I robbed a bank. But you can't testify about that because doctor-patient privilege. No, and have anything to do with your medical care. But if you had, say, been shot while robbing the bank, then maybe it would be protected. In the United States, that is not true. In fact, almost the opposite is true. One of the hearsay exceptions is for medical information. We talk about hearsay and how hearsay is all about, is it trustworthy information? It's something that someone else told you. Is it trustworthy when you then tell the jury about that? Normally, we like to hear it from the person, not from the person who heard it. Well, one of the rules is that information that you tell somebody, a doctor, for the purposes of diagnosing something, is generally trustworthy because the fiction is that you wouldn't lie to your doctor, which is totally not true. I lie to my doctor all the time. don't tell the insurance companies this, but like, it's like we said about the drinking thing. When your doctor asks you how much you drink a week, nobody tells him the truth, right?
They tell them aspirationally.
There you go. Exactly. And that's what we have here. It's aspirational. But to the extent you think you have a doctor-patient privilege, you do under certain circumstances, like HIPAA protects you in certain places, but not when it comes to this kind of thing.
And, this makes a lot of sense because the purpose of privileges, like we've already talked about, is to guarantee your constitutional rights. The reason you don't want doctor-patient information to get out is because of what Brett just said. HIPAA sorts of concerns, HIPAA being your personal information about your health. So maybe you don't want everyone to know you're pregnant or that you have cancer or that you have high blood pressure or you're diabetic or your blood type. Those are all very private sorts of information, but your doctor needs that information to properly treat you. But that information can be properly protected through different functions of the court and still allow your doctor to testify. So if what you're concerned about is that the world is going to know about your multiple diagnoses and then you're afraid people are going to look at you differently or it'll hamper your ability to, say, get a job later on because you are struggling with some diagnosis, well, there can be protective orders in place. You can have redacted or sealed filings when mentioning your health provider's care of you. And that gets to the heart of what you're worried about. But there's no constitutional right to keeping that information private. Rather, that's more of a we get it as a person. You may not want that information out there, and the public doesn't have an interest in knowing your exact diagnosis. It has nothing to do with X, Y, or Z, but they may need to testify about maybe how you shouldn't have been getting opioids, for example, and that information doesn't justify a prescription for opioids. That's important information for the doctor to testify about, but maybe the world doesn't need to know your diagnosis of lower back pain or something like that. And so when you think about it in the broad scheme of things, the court has lots of ways to protect your privacies, and they will use those tools at their disposal to protect you while still getting to the information they need for proper disposition of a case.
And a practical example of this, we dealt with this a lot during the pandemic. Everybody in jail, in prison, tried to get out on the basis that COVID was going to be really terrible in the prisons and every one of them has comorbidities and they're all going to die and so they need to be released. And everybody's filing these motions to try and get released. And of course, their medical records are incredibly important for deciding whether or not they're eligible for that. And so we filed a lot of sealed motions. Filed a lot of sealed motions with a lot of sealed information to make sure that information didn't get out to the public. But it was information that the judges considered when deciding whether or not to grant these things. Same thing in a criminal case, like Alice was saying. We don't necessarily think that everybody out there needs to know about your pain and whether or not your opioid prescription is a prescription that you needed. But when you're prosecuting the doctor who prescribed it, that's going to be information a jury needs to hear. So you don't have a privilege, but the privacy right still is protected through other means that allow for you to use this information when you need to without necessarily spreading it all over the world. And a couple other privileges that people bring up: journalist and source privilege. So journalists will often say that they have a First Amendment right to protect the identities of their sources. And there are some limitations on prosecuting journalists, but they're all policy-based. At the end of the day, if the government wants to prosecute a journalist for not giving up their source, they absolutely can do it, and they have done it before. And journalists have had to spend some time in jail for refusing to give up their sources. So we talk about that, and you may hear journalists say that, but as far as the law is concerned, it doesn't really exist. Same thing with the priest penitent type situation. And look, as we said, different states have different protections for a lot of things, so we're being pretty broad here. There are sort of levels of protection for all this stuff, but it's not universal.
And also, as you move away from the constitutionally protected attorney-client privilege and you move into kind of this other space and viewing it from a constitutional perspective, you can see how these are going to be much more limited privileges that have a lot of exceptions, kind of like we talked about with the doctor-patient. If the court can get around whatever you're worried about and protect you appropriately while still getting to the heart of the case, they will do so, because the journalist source thing, that's going to be more of whether the prosecutor wants to be seen going after a reporter who doesn't want to divulge their source, or going after a man of faith in a collar for not talking about what he heard in the confessional, especially if there is a third party or third source that can reveal that information. And so we're not saying broad strokes these don't exist, but they are much, much more limited. They are not broad like the attorney-client ones. And even if they exist in your jurisdiction, there are probably huge exceptions to them where you can get around them. And you have to understand, the reason there are such limited privileges is that you're trying to get to the truth in court. And that's why the court has the power to subpoena and to compel you to turn over documents or to testify about things you may not want to testify about, because they don't care about your embarrassment factor. They care about getting to the heart of the matter, the truth of the matter, the case and controversy before them. And they can only get that if people are willing to tell the truth. And, they're piecing a puzzle together. And sometimes they can't piece that puzzle together if too many privileges or holes exist in the final picture.
And you can see how this gets so complicated so quickly. We talked about this a little bit with the spousal privilege and how, what about all these other relatives? Well, all of these privileges we've talked about, one of the reasons that they haven't really been enshrined is because they have similar problems. If you have a privilege with your doctor, what about your psychologist? What about your psychiatrist? What if it's just a counselor? What if it's just a social worker or somebody on BetterHelp? Or what if it's just your best friend who you tell everything to? Why isn't there a privilege there when you're talking to those people? If mental health is the same as physical health, why shouldn't you have a mental health privilege? And then you say, maybe you should, but where does it end? How far does it extend? Does the person actually have to be a doctor? Do you have to meet them in person? I mean, what are the limitations? Same thing, we talked about the priest penitent. When people hear that, they think about Catholics, and it's sort of very obvious. You have the priest and you go to confessional and you say you murdered the person, and the priest is never going to testify. And as Alice said, what are you going to do? Put the priest in jail? You can't do that. But it's not that simple. When I was back doing death penalty litigation, we had a case where the defendant murdered his parents, and the defendant was Mormon. And so he's arrested, he's taken into custody, he invokes his rights under Miranda not to talk to anybody until his lawyer is present. Well, they're all Mormon. Everybody's Mormon. One of the police officers is Mormon, and he is in this guy's same temple. So he just goes into the room and sits down. He goes in the room with him and sits down. That's all he does. And the guy just can't help himself. He just starts talking to him. And he says all this incriminating stuff. And then the guy just gets up and leaves. And so there were lots of interesting legal issues here. Is this an interrogation? Should this be prevented by Miranda? Those things, we won those. Well, then there was a question of, is this a priest-penitent relationship? Because in the Mormon church, I guess, I don't know a lot about Mormonism. If you guys want to write in about it, every male who's a faithful member of the church is an elder in the church. And so the idea was he's an elder in the church, so when he's talking to him about his sins, that should be confidential. That also failed for several reasons, not the least of which that our state didn't really have very well developed privilege in this area, but it was sort of an interesting question. And you can see where the limitations of this, particularly when you have all these different kinds of churches and religious entities with different people who fill different roles, how do you figure all that out? So really, at the end of the day, there's a reason that the rule makers created an entire section for privilege and then only ended up with one. Because figuring out how to define a privilege in all these other areas we've talked about, almost impossible.
Yeah, so I hope this gives you kind of a broad view of what privileges exist and don't exist. And I think what you should take away from this is that privilege is very limited, and it's basically down to your constitutional rights, attorney-client. And there are many ways for you, the client, to pierce it, maybe even unknowingly. And so this is a primer. You can only get into so much privilege in half an hour, Brett, but I think we did an okay job.
I'm sure you guys are going to have questions and comments and confusions, and we are always happy to hear those and try to explain more. But this is a question that we've gotten a lot about. And so we did want to try and flesh it out a little bit. So hopefully it makes more sense to you guys now.
Well, Brett, do you have anything else to add before we sign off for today?
The only thing I wanted to add was, and I posted about this on Facebook and on Twitter, you guys all remember when my son was in the NICU and everybody was super supportive and we wouldn't have gotten through it without you. One of our listeners recently had a child, and when he was born, he weighed like a pound, very, very early, and he's had a lot of issues, but he's fighting through all of them, and he's doing really well. But those of you who've been in this situation know that even when your medical bills are being paid, it is really expensive, and it is the kind of thing that really runs through your budget really fast. So they have set up a GoFundMe to help this family. We have posted that both in the gallery on Facebook. It is our pinned tweet. So if you have a couple bucks that you can share to help this family out, go do that. And please keep these folks in your thoughts and prayers. Like I said, he now weighs over 4 pounds. He's doing a lot better, but they got a long road ahead of him and a lot of work still left to be done.
Yeah, and we're all a family here. You guys are here for us, and we are so happy when you share your burdens with us so we can try to help as well. So thanks for bringing that up, Brett. And as always, we are guided by what you want to know about on Legal Brief. So please feel free to write in, let us know your thoughts, any questions you have, any developments in the law or in the news that you see. Let us know about them, and we will try to cover it. Well, until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. I really like to drink water. Like, if I don't have a bottle of water around me at all times, I feel like I'm going to be parched.
I remember growing up, I would have like a huge glass of just water, and I would just, just ice water is all it was. And I would just drink it and go through it, and then I'd go get another one and drink it. And I mean, I was very hydrated. So unfortunately, though, when I graduated from water and like diet soda to beer and bourbon, it did not translate as well. But anyways.